So Hal has sort of made exactly the transition that we're hoping to make at this moment here, which is getting from understanding how real this is, how personal this is, how this affects people's lives, to thinking about the environments that make this possible. And so I found when I was trying to help Jeremy Rubin with his case, and when I've been trying to help other folks at the Media Lab and elsewhere around freedom to innovate, that I don't know nearly enough about some of these laws that we find ourselves bumping up against. And so one of the big things that I really wanted to do with this conference was bring some utterly remarkable activist lawyers up to the stage to really give us a sense for the world that we're dealing with and the issues that we're dealing with. And from what I understand, this is going to be at least as much a conversation as it would be a conventional panel. And let me just say that these three folks are folks that you would be lucky to have a conversation with. And not only do you get to have it here before lunch, but my guess is that if you buy any of them a drink or corner them later, you can have any number of conversations with them. But we have Kit Walsh from the EFF. We have Andy Sellars from Harvard's Berkman Center. And we have Shannon Erwin wonderfully from the Muslim Justice League. And it just makes me so happy that the organization is named that. I want cartoons coming out of this as well. We have a great session here, and I'm going to hand it over first to Kit.
Great, thank you. Thank you, Ethan, and thank you everyone for coming. I'm looking forward to speaking with you and hearing about your ideas for how we can make change, how we can get the White House to change, Congress to change through the courts, and move from defensive sort of legal strategy into really improving the legal landscape for everybody. I am here from EFF, and I'm very pleased to be joined by Andy and Shannon. This is a quick overview of what is going to happen in this session as far as we can predict, and we're hoping that we will go off the rails and talk about some other things that interest everybody. So I'm going to give a quick overview of a whole bunch of areas of law that impact the right to research and freedom to innovate, and do a focus on the DMCA. Andy's going to talk a little bit about the medical devices and the DMCA work that he's been doing, then the Computer Fraud and Abuse Act, and maybe some resources for innovators, because the Cyberlaw Clinic is one of them. And Shannon's going to talk about over-enforcement, selective enforcement issues. But we're going to start with that prompt. We're interested in hearing what your questions are, what you are looking forward to hearing about over the course of this session about the law that impacts these rights. And we're not going to answer those questions right away, but we will try to answer them over the course of our presentation, and then to seed the following conversation with some of that content. So if anyone has ideas about what they'd like to hear from us, we're okay if you don't. We have a plan. But is there anything that anyone's particularly interested in hearing about? Kendra?
Who is also doing DMCA work in her own right.
Yeah, I'm not going to ask about the DMCA. I'd love to hear about, you guys talk about unauthorized access under the CFAA and what sort of the limits of things that people think that are, because I think that's unfortunate but probably relevant topic to many people in this room.
Other questions? Great.
Thanks. I'm interested, like, in a general sense. This is maybe more of a frame than like a specific topic, but just like understanding as much as we can, although it's fundamentally kind of unknowable, like what the incentives and personal motivations are of the people who create these laws and also who enforce them. Why are they doing it?
So in the physical world, there are fences, and they're safe places to be, like on public streets. Well, people could argue, but behind fences which are marked no trespassing, it's more dangerous. So my question is broad, but how is it that people can know where the boundaries of where they can work are? I mean, we want to push those boundaries, but how do mere mortals know where those boundaries are? Where are the safe havens? Where should they really, really not go? Where the gray area is?
Should we, as a community, be proactive in our defense, like promoting an insurance policy of innovation?
What else we got? Great. This is my workout, by the way.
I have a similar question to the one previous about fences and boundaries. I'd like to hear if the bounding of protected computers defined by the CFAA has ever been challenged or tested in actual litigation.
So my question is about, how much do the laws actually matter, right? Or are they just so broad that people can just go after whoever they want, and how much change would it take to make that no longer true?
These guys can answer a lot of questions. Do we have one or two more? Awesome. Corey. Can't wait to hear this one.
Well, it's a question Joey asked me this morning. Could you enumerate the whole list of risks to tinkerers legally? I came up with API copyright, DMCA 1201 liability, intermediary liability, patents, CFAA, and EULAs. Is there something I'm missing? Is there a sixth set of liabilities to tinkerers that you could enumerate?
I love systemic questions.
So could you speak a little bit about the non-legal risks? So just to illustrate that a little bit more, by day I'm a medical student and I'm acutely interested in medical devices and the security of which, and if I were to research the security and very shitty security of medical stuff, I would be at risk from a professional, in inverted commas, view. That would not be sort of looked upon well by the medical establishment, and I could be at risk for non-legal reasons.
Kendra is good enough that she gets a second question, but then that's it.
Thank you, Ethan. Can you guys talk about the difference between civil and criminal liability for the various things you're going to talk about, and how those might play into what outcomes might be for innovators?
All right. Now, today on Ask an Attorney, we
So
have
charged.
10.
Great. All right. Thank you. So I think people know what EFF is, but you may not know about some of the resources that we have for innovators. On our website, which is EFF.org and EFF.org/coders, there are FAQs for people who are doing reverse engineering and vulnerability research and gray hat hacking that will address some frequently asked questions like, what are the biggest risks? Where are the gray areas? How can I mitigate my risk? And we also advise individual innovators and researchers through our Coders' Rights project. So you can get in touch with us through info@EFF.org, and we can take on individual clients and represent them. We also run a network of cooperating attorneys that we will send people to get individualized counseling, because you will not, I'm afraid, come out of this session fully able to navigate the nuances of the law. We're going to sort of do our best to raise some flags and develop some principles, and maybe try to take a stab at a systematic listing of some of the many laws that potentially affect research. But speaking to an attorney is often something that is advisable if you're doing high-risk research, either EFF, Cyberlaw Clinic, the BU Clinic that MIT is helping to set up, or other resources that maybe Andy will talk about. So this is something like a list. This is the first slide of a list of some laws that affect researchers through the lens of sort of work that EFF does to protect right to research and freedom to innovate. We've talked about Section 1201 of the DMCA, and it does matter what the law is. Even if you start with an overly broad law that's basically prosecutors go have fun, go after hackers, it can get winnowed down through decisions in the courts, through impact litigation, and the DMCA, for example, actually includes a mechanism for temporarily narrowing it, which we've used to some success in the jailbreaking and cultural remix contexts. We do work with the CFAA, which Andy will talk about that law. I mentioned the Coders' Rights Project. One thing that I'm not sure if it was in Corey's list is the way that export controls affect researchers, particularly given new legal positions and new suggested expansions of those regulations that would make publication to the internet equivalent to an export abroad to another country. So that obviously has extreme consequences for the free speech of researchers who are trying to share knowledge or simply share the code that they've generated online. And so I'm getting a little bit of feedback. Maybe we can get that fixed. But we've been doing some work in that context, including the seminal case back in the 90s where we helped establish that code is First Amendment protected speech. That was an export controls related case about whether you're allowed to publish encryption software. We've touched a little bit on general IP doctrines, on overly broad patents, on overly broad copyright regimes and copyright that lasts too long. We've done a lot of work in the fair use context, helping to establish that reverse engineering can be fair use and often is. Another threat to innovators, often in the commercial sphere, but not necessarily, are attempts to go after the platforms where people are engaging in speech or gathering to associate. And so we've helped to establish and defend law that keeps those platforms able to operate without being liable for everything that anyone does on that platform. So Facebook isn't liable if you defame someone using Facebook. That's not their problem. They don't have to police everything everyone does to make sure that it complies with the law. And that's actually a very important legal position for us to be in order to be able to have those platforms. Hal mentioned international trade agreements and the idea that the US Trade Representative could, in principle, stop trying to export hostile legal regimes to the rest of the world. The sort of most immediate example of that is the Trans-Pacific Partnership, PPP, which is in the very final stages and includes a lot of bad export of US law and expansion of US law, the sort of tightening of the regime even at home. That's what we call policy laundering, when something can't get passed through the domestic Congress and then the US Trade Representative gets an international agreement that arguably requires the Congress to implement some law to comply with it, then goes back and gets laws like the ban on circumvention, for example. We also run, we have a new project called Offline, which is support for imprisoned technologists around the world. So people who are in countries with oppressive regimes who wind up imprisoned as a result of their technological work. The network creates visibility, makes it a little bit harder for bad things to happen to those people, for them to disappear. That's a non-legal support mechanism in a way that we can all sort of help one another, even if there are unjust laws that are applied to researchers. So I'm not going to try to explain all of those laws. And actually, there's one more, as long as we're trying to be comprehensive. There's the Electronic Communications Privacy Act and the Wiretap Act. So often researchers who are doing network security research and sniffing packets need to worry about that and whether they have the permission of the people whose traffic is traveling over that network and so on. And that's something that we talk about in our online guide, the FAQ for reverse engineering and research. And that is definitely not an exhaustive list. I could add infernal machines to this list and a host of other state laws. But the reason that we've been hearing so much about the DMCA and the CFA is both because typically they are very broad. And so typically if someone is getting a legal threat, they're likely to be thrown in there. And there are also opportunities to either make some good changes to those laws, either through the courts or through the legislature, or at the very least prevent some bad changes to those laws. So the administration has been pushing CFA reform that would increase penalties. And that's something that maybe the White House could be dissuaded from backing. That would be helpful in this space. So without getting into the details of all of the laws, we'll do a deep dive on a couple. it's useful to provide a couple of big picture concepts that technologists may not be familiar with. The first one is just sort of a very vague normative statement, which is sort of meant to provoke conversation and thinking about like what are the principles that we should aim towards as we are proposing revisions to these laws. And so treat that as something that's there to provoke you into thinking of other language and other concepts. But another way that lawyers think about problems that is not always familiar to technologists is that there's a spectrum of risk associated with these laws. So there's not a formal definition in the law of what conduct is and is not covered that actually unambiguously resolves all of the cases that arise in the world. There is language in the law that, that may have been written by someone non-technical that may or may not matter. There may be a definition that itself needs to be interpreted, but what you wind up with is a spectrum of risk both within each law, but also in terms of what laws may be brought to bear against your conduct. So for example, one rule of thumb is that it's riskier to try to do research that involves a device or network that you don't own, particularly if you're not authorized to interface with it. But even if you are working with a device that you do own, that's the remarkable thing about the DMCA in section 1201 is that liability can attach for you working with hardware and even software that you own. So there's a spectrum is the point there. And whenever you're operating in that gray area, you are at risk of legal bullying because there can be an argument on the other side that what you're doing is unlawful, particularly if no court has ever decided it or the courts that have decided it govern different geographical areas than where you're engaging in the conduct. Then it's very easy for someone who is upset about the vulnerability that you have disclosed or the market that you might be disrupting with your innovation, or simply sees an opportunity to extract some money through nuisance litigation like patent trolling. It's very easy for them to force you to spend a lot of money going to court or back down because you may not be in a position to fight back legally. So I have a few ideas for how we can support innovators, researchers, and move both the law forward and provide some social support for one another. One of the things that EFF does quite a bit of is impact litigation. So what that means is when a case comes before a court and we're able to represent a client or put in a brief to inform the court and get that case to turn out the right way, that doesn't just benefit that person, it benefits everyone who's subject to the jurisdiction of that court. So this is like the Austrian Emperor's Prize, basically. You have taken a risk, you have some legal risk, but if you can get a court to resolve that risk in your favor, then the prize is not only you're off the hook, but everyone who comes after you is now able to engage in that behavior. So that's a model of change that organizations like EFF and ACLU use to try to protect legal rights of people generally. We can't just go and challenge laws whenever we like, particularly when they involve private rights. There needs to be someone actually taking that legal risk that we can represent, take on as our client, and advance their rights. So sometimes it's difficult to pursue this strategy because either the opposition sort of catches on to the idea that maybe they shouldn't bring these claims, or the penalties for being wrong are so egregious that it's really painful to be a client in that situation. So that's true not only for civil cases, particularly copyright, where the damages are not in any way tied to the harms that are inflicted, but particularly in a criminal case, if the downside is you might go to jail, you shouldn't, but there's going to be a trial and there's no guarantee that you won't go to jail, there's a really serious cost to the people who are involved in making change in that way. Obviously, you can change what the law is through the legislature. You can change the policies of enforcement through the executive branch, through Department of Justice guidelines. Those are sort of the more legal avenues of change. just events like this or Know Your Rights events are ways to dispel myths that might chill you from engaging in conduct that is arguably lawful. There may be there are a lot of sort of rules of thumb that flow around about the law that are not necessarily nuanced or may reflect an especially risk-averse view of the law. And so learning your rights and helping your peers and others to know their rights is a way that we can support one another as well. Institutional support, so either if you are an institution supporting your students in the ways that we've talked about, or if you're a student pressuring your institution to do that. And another thing that we do is just shaming companies and prosecutors who abuse the law. And it's can be quite effective in the context of private actors who are trying to protect their reputation. They don't like that a security vulnerability has been disclosed, so they're going to threaten the researchers. If you make a big stink about that, then sometimes they can back down if their interest really is reputational. So I'm gonna quickly, we already had a great introduction to this from Jonathan, so I'm just very quickly going to talk a little bit about the DMCA, but also how we got the DMCA in response to one of the questions that we got. So the DMCA was passed in 1998, and the sort of most salient use case of it that would have been in people's minds is a DVD that has encrypted media content that is the kind of content that would be widely disseminated on file sharing sites. And so the thought was, if you ban the act of cracking that encryption, that will reduce the amount of infringing copying that goes on. And so various interest groups raised a variety of objections to the very broad wording of the DMCA that encompassed all copyrighted works and didn't seem necessarily to be adequately protective of fair use rights. And so we got some carve-outs that don't necessarily make sense, like the library carve-out. There are also carve-outs for security research, encryption research, and reverse engineering, and all of them are significantly narrower than your fair use rights would be in that space. So it's not, they could have written in a very explicit savings clause for fair use, saying if you're circumventing to make a fair use or to do something that's not an infringement of copyright, then that's fine. We and the courts have already said that's not a problem. You're allowed to engage in those activities with copyrighted works. But they wrote it in a way that doesn't clearly effectuate that intent and has been interpreted by most courts not to allow fair uses, which is the single largest reason that the DMCA is such a menace to research and innovation, is because we've thrown out the traditional safeguards for innovation, for free speech, in favor of a regime where circumvention is presumptively banned unless it's within one of these very narrow statutory exemptions, or you engage in rulemaking which you can participate in once every 3 years. The statute sort of recognizes, all right, this might have some adverse effect on people who want to do legitimate things with copyrighted works. So the way we're going to fix that is, once every 3 years, you can go and ask the Copyright Office and the Librarian of Congress to create an exemption for the subsequent 3 years that makes it clear you are allowed to engage in the conduct for which you applied for an exemption. And so it's not a useless process in that we've gotten things like jailbreaking of smartphones, and once you have legal clarity around that, a market can develop. You can show the sky doesn't fall. It's actually really valuable to have these exemptions to 1201. But it is a very onerous process. The Copyright Office is not as friendly to exemptions as you would hope. And once you get it, you have to reapply for it every 3 years. So basically what happens every 3 years is the public interest organizations that have the bandwidth figure out how much they can do within their bandwidth and what's high priority, and go and ask the government for permission for people to do harmless, legitimate activities. And if approved, so typically you'll get either nothing or something narrower than what you ask for, and then that will last for 3 years, and then you do it again. So that's the DMCA regime. It's very much a sort of permission-based regime. The default is you need a manufacturer's permission to look at, for example, their code, even in a product that you bought, even code for which you own that copy. So it's not necessarily a licensing issue, which actually let's add contract law and ULAs to the big list of legal threats to hackers. It's actually stuff that you own, but you're not allowed to look at how it works. So this cycle, EFF is directly seeking 6 relating to vehicle hacking and security research, and video game preservation, mobile device jailbreaking, remix, and others are seeking 21 additional exemptions, including the Cyberlaw Clinic working on medical devices, which Andy will talk about. And excitingly, we're expecting a final rule by October 28th. So the White House only has a little bit of time to call up the Department of Transportation and the EPA and ask them to stop opposing the vehicle exemptions and call up the acting Librarian of Congress and suggest that maybe security researchers and other tinkerers could use some more freedom to operate in this space. I'm going to skip through. So I just talked about the triennial rulemaking, and I think Andy is going to talk about medical devices or whatever Andy wants to talk about next.
Yeah, let me take you through a case study of the DMCA rulemaking process through the clients that the Cyberlaw Clinic is representing. So we represent 4 different researchers that are doing 4 different types of research around medical devices. One is doing straight cybersecurity type work. So Jay Radcliffe looks at insulin pumps in particular and vulnerabilities in insulin pumps that allow for radio frequency attacks that allow them to do things like discharge all their insulin at once, or don't discharge any insulin ever again. Things like that, by virtue of being radio frequency attacks usually have to be short range. They've never actually happened in the real world, and the way that they're portrayed in the season 2 finale of Homeland is completely wrong. But this idea that it's out there that there are basic, we were talking about this in the medical device space earlier, there are basic fixes in insulin pumps that they could do to prevent this sort of attack that they just haven't done, like authenticating the signals that are coming to them. Another one of our clients is this guy by the name of Hugo Campos. He is a cardiomyopathy patient. He has an ICD implanted in his body that regulates his heartbeat and occasionally gives him shocks when he needs it for atrial fibrillation. His device measures an incredible amount of data about his heart's activity, but does not actually share that with him until he goes in for his 6-month checkup. Whereupon he'll get a dispatch that says, oh, did you know that on February 18th at about 10 a.m., you had a bad heart incident, your heart had a flutter. So whatever you were doing or eating on February 18th at 10 a.m., don't do that again, because that could have been really bad. That actually could have almost killed you. He has had to develop a very elaborate system to track his life and his daily activity so that he can cross-reference what comes back every 6 months later. Meanwhile, his device every night when he's home will dispatch that information off of his device. He's figured out now, well, I could just sort of sniff the transmission that comes through and then get that data to myself that day rather than having to get these 6-month check-ins. But there's a question about whether or not he can do that because the outputs of the device are encrypted. They may not be protectable under copyright as a work, by the way, which is a really interesting copyright law question, but the medical device manufacturers certainly assert that it is. And there is potentially enough selection in what gets dispatched that there could be, but nevertheless, he's addressing that as well. Karen Sandler is another one of our clients, also a patient. All 4 of our clients are actually both researchers and patients. Karen looks at, in particular, malformed code, bad code. We get focused a lot on hackers on medical devices, but in fact, it's actually bad code that is what is killing people today. Hundreds and hundreds of deaths have been attributed to software failures and hardware failures and interface failures on medical devices, going back a long ways. She looks at that in particular. She was placed in the situation where she needed to get a pacemaker at a very young age, at about 35, and wanted to know what the code was, wanted to know what the code was doing, was asking the device manufacturers, could I audit the code that's going into my body, and being told no. And so is now trying to help people do reverse engineering on explanted devices to at least see the code on one device that's out there. Ben West is the fourth. He looks at getting better data off of insulin pumps. He's been dealing with, actually, I should say, continuous glucose monitors. He's been pioneering a lot of things around sharing continuous glucose monitor data with family and loved ones. It's very difficult for a patient, a child who has diabetes, to do things like go to a sleepover because their diet has to be so monitored by their parents for fear that they might have a diabetic attack of some form. And so he has been working on this idea of sharing continuous glucose monitoring data with parents, with siblings, with loved ones, so that you can live a better life by having other people watching your health while you're off doing the things you should be doing as a kid or as a parent. And so each of them confronts this from a slightly different perspective, but all are trying to get access to the source code and data outputs of personal implanted medical devices. And so that was sort of our framing, is these are personal medical devices, implanted medical devices. We're looking to get the source code and data outputs, and we're looking to get them in order to look at the safety, security, and effectiveness of the devices is the three-word phrase that I invented about a year ago when we started doing this process that we've been sort of latching onto ever since. This is sort of this weird moment where I work a lot with students. Obviously, the Cyberlaw Clinic has a small army of students that work with us. But I was sort of confronted, like sitting at my laptop one day, about a week or so before our initial petitions were due last November, and had to sort of say, like, okay, time for me to write what might become the rule. It's a weird bit of legislation from my laptop. It was sort of like, it should say this, and it should say at the direction of these people instead of by these people, because of course the patient may not be the software expert that could actually do this reverse engineering. And so there's a little bit of crafting that had to go along the way. When it came time for opposition to come out in the spring, we had opposition from the people you'd expect. So AdvaMed, which is the Medical Device Manufacturing Coalition, opposed our exemption. The National Association of Manufacturers opposed our petition. We had a couple of other life science people and trade organizations come out, and we had this random guy named Jay who was really concerned. And I don't want to belittle Jay. I later researched and found out that Jay, in fact, works for one of the medical device companies, so I figured out why Jay was so concerned. But it was amazing because this is supposed to be a copyright thing, right? Our concern is piracy. And in the case of medical devices, we don't have the piracy concern, right? No amount of access to the source code of a defibrillator is going to replace the need for the defibrillator, right? It's exactly why it is useful is why it is needed. You can't actually have a piracy problem in this space. And none of the exemptions said anything about copyright. They didn't say it at all. Their concern was, of course, the sort of general fear, uncertainty, and doubt. These people don't know what they're doing. They're going to screw this up. Patients can't understand this data, which when you talk to a patient like Hugo, who is now like in residence at Stanford because he just became so invested in this that he started researching and researching and researching, never stopped and became an expert, like that's insulting to someone like Hugo who studies this stuff so deeply. And so they kind of tried to paint all of this fear and uncertainty around it. Well, the advantage that we had is that their security on these devices was so bad up to this point that many of these devices had no technological protections measures on them whatsoever, which meant that this research had actually been happening for a long period of time. And we could point to a history of this research being done, and not only helping to save lives, and there are folks like Kevin Fu who has done this and has launched his whole career around security of medical devices, but we could actually show the FDA and the Department of Homeland Security and others citing these pieces of independent research when they were actually regulating the safety of these devices. So our response was two-pronged. One is that the Copyright Office isn't really in a good situation to gauge safety and security. The FDA is, and the FDA relies on this research. So you are actually going to cut off a source of information for the government to regulate if you prevent this sort of research from happening. Because of course in situations like malformed code, it doesn't matter how obscure it is. If the code is bad, the code is bad. And we need to find out because we need to make the code good. So I feel pretty confident that we made a good argument there. I will find out on October 28th how good we were. But it has been an amazing thing for me because I came to this originally from a copyright background. When I was in law school, I thought I wanted to be a music lawyer. And so I mainly focused on copyright, and I learned as much as I could. I have had to cite so little copyright law in the DMCA proceeding. it is a bit crazy. In fact, mainly what I'm citing is facts, right? What I'm mainly citing is don't be afraid. In fact, this is good research. And if there are concerns about disclosure, there's a robust ethical considerations that already exist. There are norms in this culture as to how to share this information and where, and here's all this good evidence of people doing the right thing. We are so far beyond the anti-piracy concerns that started the DMCA that we're regulating things like emissions through this. We're trying to opine on matters of health. We're really kind of really far afield of what this was originally designed to do. So it is the problem of overbroad laws is something that we've talked about a few times, and I know, Shannon, you're going to talk about overbroad laws as well. But it is that concern. It's what Starr mentioned earlier, this sort of disorderly conduct charge, which no one can really ascertain what it means or what it does, but it applies nevertheless. It leads to this concern that Robert Jackson, who was at one point the Attorney General of the United States, later became Justice Jackson, wrote about when he wrote an essay called The Federal Prosecutor, and he was concerned about these overbroad laws, meaning that the prosecutors were no longer going after laws, they were going after people. It's that same sort of feeling, that same sort of fear. And we in the computer world and in the technology world are seeing a slice of what has been true for so many other types of people for so long. Robert Jackson wrote about that concern in 1940, and it could go back easily 2 centuries before that. You can find similar inklings and notions. So anyway, I'm a little far afield, so the DMCA has this problem. The Computer Fraud and Abuse Act has the same problem. I could go through today and talk about the either 7 or 13, depending how you count them, different crimes that are within the Computer Fraud and Abuse Act. But they all hinge around this common idea, and it's already come up a couple times, and it's this question of authorization. So for example, if you enter into a computer, and query for a second what that exactly means, you enter in a computer and you obtain information from that computer, and you did so without authorization, that's pretty much all you need for one species of a CFAA violation. If you knowingly inject code and your code causes damage and loss, even if you did not intend it to do so, that's another way that you can have a Computer Fraud and Abuse Act problem. There's a few others as well. But this question of authorization, which is obviously pivotal to CFAA, is so radically under-theorized. And I think there's been some interesting literature about it. Oren Kerr writes about this all the time. His most recent essay is calling back to norms to define the space, which I think works. We were talking about fences and trespass. We have a sense of what that means, though we still get Supreme Court cases about walking police dogs up to the fence and whether or not that, in fact, is a trespass in that sense or not. But we kind of get what it means in the physical world because we have millennia of experience. We are so new to this space, we don't know what that exactly means. And Kerr posits a theory of what he thinks it should mean. And as a person who went to GW and studied under Oren Kerr, I'm inclined to agree with much of what he says. But he posits his worldview, and I think that if we were to poll the room, we'd probably get many different worldviews. Questions like, is it true that any URL that's publicly accessible should be retrievable if you enter in that URL? I think so. Kerr also agrees with me there. But it's that same notion. I think if you were to ask AT&T, they would say no. And in fact, Kit and I worked on a brief in the case that I'm sort of circling around, the United States versus Ornheimer case, about exactly that notion as a matter of the Computer Fraud and Abuse Act. If you think about, for example, you go to Voltage down the road here, and you want to get on their Wi-Fi, and you don't know the password because it's hidden somewhere. So you go online on your phone, and you find it, and you find the password, and then you type in the password, and you get online. You have done password guessing. We have a case on point, and in fact involves a man who's now a professor here at this institution that says that is a CFAA violation, but it feels so benign, it feels so common. It's something that I think all of us have probably done at some point. I will admit I have done that before, in case Carmen Ortiz is listening. But it feels like it should not be a crime because it feels so common. And maybe if you ask Voltage Cafe, they feel differently about it, right? And so there's a lot of uncertainty in the space, which means that when folks like Berkeley recently published a white paper at the Berkeley School of Information and the Berkeley Center for Law and Technology talking about the legal impediments to cybersecurity research, they found themselves going to soft power. They found themselves going to private ordering, this notion of the contracting we do around these institutions as places where the real action often is. It becomes a political fight because the law is so uncertain, which means that as lawyers, we have a dual obligation. We have an obligation not only to say, here's our best understanding of where the law is today, here are some potential vectors of where it might go tomorrow, but also you should think about the political ramifications of this. You should think about the ethical considerations of this. We have this idea, John mentioned it last week, Jonathan mentioned this idea of wise counsel, which I think is a really nice way of thinking about what a technology lawyer's job is in the space, a person who is 1 degree removed from the activity, so can maybe get a sense of what it looks like from the other side of the wall, but at the same time has your back, has your support, or is supporting you, and is out there to do the things that you want to do. So I didn't actually tell you anything about the substance of the CFAA. I hope that's okay. I'm happy to take one-on-one questions, but I actually would love to turn it over to Shannon and talk a little bit about this idea of broad laws, because I think Shannon's work sees this better than either of us.
Great. Thank you so much, Andy. And wow, I was able to operate the mic, which surprises me because I am certain that I am the least tech-savvy person in the room right now. My name is Shannon Erwin, and I am an attorney and executive director of the Muslim Justice League. We're a very new organization formed last year in order to advocate for human and civil rights that are being violated under the war on terror. So for rights that are being eroded for national security, supposed national security reasons. One of the programs that was really the impetus for our founding is called Countering Violent Extremism, or CVE, which is quite a case in point of overbroad and selective, not necessarily prosecution, but chilling of viewpoints, and I'll talk about that a bit later. When I was asked initially to speak on this panel, I was really excited and intrigued because the parallels between our work at the Muslim Justice League and the work of tinkerers and innovators were honestly not something that I had given much thought to. And yet, in starting to speak with Andy and Kit about their work, I recognized that there are so many parallels, and specifically one area in terms of overbroad and selective prosecution. A theme is, state authorities in the case of national security laws, but I think it could also be powerful private interests, certainly in the case of freedom to innovate, seeking to discredit or marginalize or chill or criminalize oppositional speech, awareness raising that is threatening to their interests. Right, and so I was asked to speak specifically about material support prosecutions because that's what most directly impacts our Muslim communities right now in terms of overbroad prosecutions. And so to give a little bit of background on the material support statute, since 1996 there has been a criminal law against providing funds, goods, material, personnel, training, or expert advice or assistance, the latter part actually added under the Patriot Act, to terrorist organizations, and it's any organization that our Secretary of State designates a terrorist organization. That may sound somewhat innocuous, but when you think about it applied in practice, what exactly is, in particular, expert advice or support, right? So there was a case, Humanitarian Law Project versus Holder. I don't know how many lawyers are in the room who are aware of this case, but this is a very important case for understanding just how broad the material support statute can be. Before that, I'm just going to briefly flag, and my apologies if this is basic for anyone in the room, but another critical First Amendment case, which was Brandenburg versus Ohio in 1969, where the Supreme Court said that it is not constitutional to prescribe advocacy for violent methods. There's an exception for if you are actually advocating in a way that is likely to provoke imminent unlawful action, but just advocating the use of force or advocating violence is protected First Amendment speech under Brandenburg. Enter Humanitarian Law Project versus Holder, which is not about advocacy for violence, but rather about an organization, the Humanitarian Law Project, and some other organizations that wanted to provide support to Tamil Tigers. The Humanitarian Law Project wanted to support the Kurdish Workers' Party, the PKK, and specifically not to help them commit violence because they are a designated terrorist organization, but rather to help them explore lawful and peaceful means to advocate and to resolve disputes, and also to do some human rights monitoring of Kurdish areas in Turkey. So these organizations, Humanitarian Law Project, and the organizations that wanted to provide similar peaceful assistance to Tamil groups, asked for a determination of whether or not their activities would be prescribed by the material support statute. And the Supreme Court ruled that they would be. The Supreme Court ruled that even the provision of legal advice or assistance would be prescribed by the material support statute, which seems frighteningly broad to me. You know, when I think about the implications of, you know, for national peace, international peace and security, of telling human rights groups, legal advocates, that you are not allowed to promote peaceful methods? What sort of remaining channels are there for folks who legitimately want to affect change in situations of human rights abuses? But even the Humanitarian Law Project case was not as broad or as frightening as the landscape that we find ourselves in now. Because the Humanitarian Law Project Court did specifically say that, you know, although we are finding that these particular activities would be unlawful under the material support statute, we note that these activities would be done in coordination with or under the direction of a listed terrorist organization. And the court specifically said that independent advocacy could not be constitutionally criminalized, consistent with our First Amendment protections. So they made that statement, and yet we find ourselves today in a different place. The material support statute has been used, its use has escalated since 9/11. There were only 6 cases where it was used before 9/11, although it was in existence since 1996. And there were almost 100 cases in the 3 years after, or excuse me, the 6 years after that. There have been about 500 cases, more than 500 between 9/11 and 2011 of national security or counterterrorism related prosecutions, a large portion of which rely on the material support statute. So one crucial case that I wanted to discuss happened here in Massachusetts, and that was the prosecution of Tariq Mahana. Tariq Mahana was from Sudbury, Massachusetts. He was a pharmacist. He was Muslim. And like many Muslims and many people who are paying attention to foreign policy, he had a lot of objections to American imperialist ventures. He had strong objections to the war in Iraq, and he advocated that Muslims have a right to self-defense in areas where they are under occupation, such as Iraq. In terms of his actual activities, he would caption so-called jihadi videos. He also translated a document called 39 Ways to Support or Participate in Jihad, which actually talked about nonviolent methods to engage in jihad, which is a Muslim principle meaning struggle. It does not necessarily connote violence. It can connote self-defense, but it can connote a lot of peaceful things as well. But one thing that was crucial in his case was he refused to be an FBI informant. So Mahana, like many young Muslims, was visited by the FBI. He was told that, you know, he was invited or encouraged or coerced to become an informant. He was told at one point, according to his recollection, by FBI agents, we can do this the easy way or we can do it the hard way. If we do it the easy way, you'll never see the inside of a cell. Meaning, if you work with us, if you act as an informant, we will not prosecute you. For basically some false statements that he had in fact made to the FBI, but also for material support. He refused to act as an FBI informant. And so our US Attorney's Office in Massachusetts prosecuted him for some false statements to the FBI, but also for material support on a couple of bases. One was they alleged that he had in fact gone to Yemen in 2004, and he said that that was for learning Arabic and religious instruction. The federal government, the federal prosecutors, alleged that he went there to try to join a terrorist training camp, which he denied. And the other basis was that they said that he had supported terrorism, supported Al-Qaeda specifically by acting effectively, in his own view, as a media promoter of Al-Qaeda's views by his captioning these videos and by his translating this document, 39 Ways to Support or Participate in Jihad, which had been translated many, many times. It was already widely available online. And the prosecution really played up the idea that Mahana was dangerous because of this theory of radicalization, that his putting his viewpoints out there, his sharing information, his sharing outrage at American foreign policy could radicalize other Muslims to become violent. There was no evidence and no attempt to show that his activities were done in coordination with Al-Qaeda or any other designated terrorist group. And that's really key if we think back to Humanitarian Law Project versus Holder, right? That was explicitly a requirement of speech being criminalized under the material support statute. Nevertheless, Tariq Mahana was convicted. It was unclear from the jury decision whether he was convicted on the basis, in terms of the material support count, on the basis of his travel to Yemen or the translation of documents. It almost wasn't even asked publicly, that question, because when it comes to terrorism cases, I think the prosecution is given very wide leeway. That's not surprising given the climate of fear that we find ourselves in, right? And he was sentenced to 17.5 years. So since that time, we've continued to see, in federal prison and supermax prison, right, solitary confinement. Since that time, we've continued to see a number of material support prosecutions. I don't know exact data on whether they are increasing, but I suspect that they are. I wouldn't be surprised if they are. We're certainly reading a lot about cases of youth being charged with conspiracy to provide material support because they buy a plane ticket to Turkey, right? And they are alleged to be planning to fight with ISIS. And in many cases, those prosecutions are supported, propped up by evidence of online social media use. If somebody expresses outrage about foreign policy, if someone, certainly if someone expresses support of ISIS, that is used as sort of evidence that they were intending to provide material support by joining ISIS. And so all of this, this broad prosecution of what otherwise has been, to date, protected, First Amendment protected speech, and selective prosecution specifically of a suspect community, of Muslim communities in our case, I think has a lot of parallels with what you're seeing in terms of prosecution of tinkerers and folks who are trying to innovate. And it's not only those two groups either. We see under this so-called Countering Violent Extremism program that other groups that are likely to be targeted include environmental activists, including also people who challenge capitalism, the tenets of capitalism in any way. Those folks are likely to find themselves in the spotlight of a Countering Violent Extremism program, which ostensibly seeks to prevent people from becoming radicalized to terrorism. But it relies on these debunked theories that ideology is correlated with political violence, which all the empirical evidence shows is not the case. There are plenty of so-called extreme or radical ideologies, or people who hold those ideologies, and never commit violence, and there's not actually a correlation. But this is a convenient, I think, theory, and it's been around since about 2005, when there were a couple of terrorist attacks in Europe, and also when the insurgency in Iraq was really problematic for Western powers in Iraq. These are convenient theories, and I think this gets to a question that somebody asked, I forgot who, but about the motivations for these statutes and these prosecutions. And what we're seeing both in the use of the material support statute to criminalize speech, to criminalize advocacy and awareness raising and information sharing, I think is that there is a motivation of silencing criticism of certain American policies. Certainly it sounds like in the tech world there is a, I don't want to jump to conclusions, but an intent to silence criticism of unsecure platforms or you know, any vulnerabilities that could hurt a bottom line, perhaps. And these are really concerning effects that we're seeing in terms of chilling speech as well. I hear from many Muslim parents and Muslim youth, how do I know what it's safe to say online? How do I know, you know, is it okay to talk about being concerned for folks in Syria? Many parents want their kids not to use social media at all because they're terrified that they will be at risk of prosecution. And it's hard for me to think that that is fully unintentional, that that is an unintentional consequence of this extremely overbroad and selective prosecution. Ultimately, I think the folks who have created these laws, interpreted these laws, and prosecuted selectively under these laws, in some cases would like to see less of that oppositional speech, less foreign policy criticism. But ultimately, that is going to have a very negative effect on our society in terms of taking away the free public debate that we really need to have if we're to arrive at peaceful, lasting solutions for the conflicts that we're seeing. The conflicts that ostensibly these laws want to address, right? But we're driving dissent underground through these methods. So to end with something very I mean, in contrast, slightly hopeful. I guess I would talk about a couple of possible channels for change that we see. At the Muslim Justice League, we really see change needing to come from the grassroots. Not only the grassroots, certainly legal advocacy, policy advocacy is crucial, and as a lawyer, I have a little bias in that area. But we also know that policymakers, prosecutors are not going to take their marching orders from lawyers alone and advocates alone. If they can secure the participation of grassroots communities in these programs such as Countering Violent Extremism, which, to explain a little bit further, inserts surveillance into the social services sector, the education sector, and basically asks Muslims to spy on other Muslims, asks teachers to spy on students, healthcare providers to spy on their patients, and unnecessarily and wrongfully designates certain viewpoints as being indicators of future violence in contrast to the scientific evidence that's out there. If prosecutors and other organizations, and it is the Department of Justice that is leading this program, by the way, primarily in Massachusetts, if they can secure the participation of grassroots community organizations and faith-based institutions, it doesn't really matter to them what the attorneys are saying, right? So for that reason, we think that increasing awareness and increasing grassroots advocacy is really important. And there's a campaign in the UK called Students Not Suspects, which is very inspirational for me. The National Union of Students and the Universities and Colleges Union have come together and said, we will not participate in the UK's sister program of CVE is called PREVENT, short for Preventing Violent Extremism, and it's now been legislatively mandated that teachers participate and healthcare providers and others. And they have actually said, we object, we will not spy on our students, we will not engage in this racial and religious profiling endeavor. And I think that that's very powerful. If the people who are most directly impacted recognize that this sort of overbroad criminalization of speech and information sharing is contrary to their mission of promoting dialogue on university campuses, I think that they are some of the people best positioned to push back. And so I think I've probably spoken enough before we turn over to a more conversational format.
And so we'll take some more questions in a minute. I don't think we fully addressed Kendra's question about the difference between civil and criminal causes of action. So maybe we could take just a second to do that. So for people who are not as familiar with the justice system as lawyers have to be, civil causes of action allow private parties to sue one another. And so as opposed to criminal causes of action or bases of prosecution, under which the government can prosecute you to potentially put you in jail or fine you under a different set of procedures. So both the DMCA and the CFAA have civil as well as criminal components or causes of action. So in the case of the DMCA, if you do the conduct commercially and willfully, then it can escalate to criminal violation. Sometimes that's not a problem for researchers because you're not doing it commercially, but it may be a problem for innovators if you are. The CFAA also has both civil and criminal causes of action, and two major differences sort of across the board for criminal and civil are in a criminal case, you can be put in jail in addition to the financial harms. And so the penalties are potentially much harsher. There are different procedural protections, in part because you may be put in jail, but also the way that the statutes are interpreted may be a little bit narrower, again, because you need to be put adequately on notice of your rights before you can be punished, and the adequacy of that notice varies slightly depending on whether the punishment is imprisonment or financial. In the civil context, one of the interesting differences is that it is possible for prosecutorial discretion to manifest as restraint. It's possible if an agency is responsible for enforcing something that they might not be interested in enforcing something, particularly if it only implicates a company's private interests. So if you turn something that is a public cause of action into a private cause of action, a civil cause of action, you can, in some cases, enable more anti-competitive behavior. So this is something that we've seen in the vehicle-related exemptions where the automakers say, look, there's this EPA regulation that ban some of the conduct that people might theoretically engage in if they circumvented equipment. And one of the responses is, well, yes, and the EPA will determine whom it makes sense to pursue under that cause of action, not a manufacturer that has an interest in locking down the aftermarket for competitive reasons. Is there anything anybody else wants to talk about in terms of civil and criminal?
You know, the thing, when I'm thinking about this space and I'm thinking about this new BU MIT clinic that's thinking about launching, and I think about actually, it's already come up a couple times now, which is the First Amendment. Hal sort of alluded to it when he talked about hacking as a religion. We talked about it in the Holder versus Humanitarian Law Project case. But I think about the tradition of the First Amendment and the free dissemination of even scary ideas, and I think about journalism. I just want to quickly flag, Frank Lamont is here from the Student Press Law Center, who's been doing incredible work with student press for many, many, many years. This organization is just truly incredible in terms of the way that they've been able to foster journalism on campus, even journalism that is critical of the institutions in which they are housed, sometimes actually funded and housed. And the history of the First Amendment's push in the journalism space has been a push mainly in civil realm, because the idea of criminal only gets raised in the very scariest of times, right? It's the Pentagon Papers, right? It's the couple of times it was suggested in maybe one affidavit or one filing in one case, and all of a sudden the press just seizes upon it and throws it back at the administration until they apologize and capitulate. We're in a different space in that respect, because so much of what's going on here is criminal. And the risks that a journalism institution can take, which back in this area was extremely well funded, and also was facing at most money damages and loss, are a different calibration of risk than a student which has neither the money nor necessarily facing only a civil charge instead of a criminal charge. That puts a lot more pressure on us. But the advantage of these laws are that they are both civil and criminal. And so whenever there's a civil lawsuit that starts to percolate in either space, I think organizations that are interested in impact litigation probably would like to talk to you, because the ability to move the law in those spaces is a lot more palatable than it would be in the criminal space.
So we've got time for a few questions here. If folks have any unanswered questions after our opening 10 questions and the excellent attempts by the attorneys on the panel to answer them, if anyone has stuff to bring up, I knew Earhart would have stuff to bring up. Please introduce yourself before asking your question.
Hi, my name's Earhart. I'm here at the Center for Civic Media at MIT. Shannon, you were talking about this kind of the ways that you have this overbroad interpretation of the laws that end up basically making everybody complicit into the practice and protection of those laws. And I'm curious about how that may have been manifested in some of the technology laws that we have now. Do we see ways that, you know, we are getting innocent bystanders swept up by these broad nets of the technology laws that you're describing? You know, are there ways in which, you know, we might be supporting or advocating for our friends that are working on this stuff and thus become culpable or liable in certain ways? And I'm curious about the state of the law and how that affects what we should be doing for our fellow students.
I don't know that I can speak to that in the tech realm so well, in terms of people.
So, in the context of the Digital Millennium Copyright Act, you have liability both for the act of circumvention, but also for disseminating tools, and sometimes that's considered even knowledge about how to effectuate that circumvention. So in terms of infectious liability, it's certainly the theory of the entertainment industry that people who are discussing ways of circumventing access controls on copyrighted works are potentially themselves now violating the DMCA's ban on circumvention. That obviously has even more significant First Amendment concerns than the basic ban on circumvention does. So that's something that I think the entertainment industry is shy about asserting, because if we got it before a court, there's a good chance that that gray area would be resolved in a direction that would narrow their ability to intimidate through the law. In terms of, Andy, did you come up with any other areas of law while I was talking about the DMCA?
I want to echo the ECPA, the Electronic Communications and Privacy Act, which involves a lot of, it comes into play when you're dealing with real-time interception of data. But I also want to flag there are a lot of these general criminal laws in both state and federal law We mentioned disorderly conduct already. Wire fraud is just this very, very, very broad law that has this huge criminal penalty potentially behind it. And it can come up in almost any of these cases because the idea is that you're going to take something from someone and you're going to use electricity in doing it. That's kind of all you really need in order to start your way towards a wire fraud prosecution. And so the mail fraud has a very similar idea except using paper, and not necessarily paper actually in mail fraud. So it can get really complicated. So there are these sort of add-on crimes that I know came up in the context of the Swartz prosecution because Aaron Swartz was also charged with wire fraud amongst the other crimes he was charged with. And it's been raising this question that I think is definitely far beyond our community. It touches the whole criminal justice system, right? When I was trying to understand what happened in the Aaron Swartz case, I looked first to the CFAA and I tried to understand what happened there. I found myself by the end reading literature by folks like Bill Stuntz, former professor at Harvard Law, died just very recently, and he talks a lot about the collapse of American criminal justice. I think that's the title of his book. And he talks about this idea of this complicity and this inability for us to recognize how broad our laws have gotten, how much discretion is given to prosecutors, and also what happens to a person once they go to prison. We don't talk about prisons in this country, despite it being such a huge part of the criminal system. And we need to recognize just what it is we're doing to people when we're charging with a criminal law. And we need to be vocal as bystanders, as people who are related or potentially affected secondarily, in addition to thinking about our liability in the space. I think we need to, it's on us to signal to the mechanisms of power that this is, like, the activity that we're seeing targeted today is not wrong, and it is not scary, and it should not be a crime, and it should not be a crime for which we put people through one of the worst human experiences we put people through, which is prison.
Quickly, because I was hoping that you might have examples about where there were expectations that we police ourselves or police the people that we work with. Because in the case of like MIT, is there a reason maybe legally where they're not acting because they don't want to admit any sort of liability and kind of some sort of expectation of policing their community?
Well, so one of the reasons why institutions don't get directly involved with cases against their employees or students at the institution is because they might have some kind of control over that employee. There might be some layer of direction of what that employee does that potentially raises the possibility that both the individual and the institution will wind up being defendants. And so MIT's lawyers, the general counsel, represent MIT, and ethically, if there were a difference in the interests or a potential difference in the interests between the individual and the institution, they simply might not be able to take on the representation of the student directly, which is why it's good to have some kind of level of separation between the general counsel and an outside clinic or outside attorneys who really are focused on the interests of the individual and can advance them, even if it winds up being detrimental to the institution.
There was some talk of carve-outs in various laws. I know the EFF publicizes winning cases, but is there a list of things that people definitely can do? Okay, he or she just did this, and therefore I can too.
So,
yeah, it's hard to craft such a list because in copyright certainly there's this idea, this notion that comes from a few different scholars about tolerated uses. That uses that are on the edge, that may or may not be legal, may or may not be a fair use, but are nevertheless tolerated. So anytime you have a person who does something and does not get sued or gets sued and won, it can often be difficult to advise. But that is in fact what lawyers do, is they look to precedent to try and navigate a path. I don't know if there's a particular area where I'd say sure shot would do it, and I definitely wouldn't say that here, because I fear what someone might do, get in trouble and then go after me. I would say that the notion of access and authorization in some jurisdictions is actually much better than others. So the Ninth Circuit in California and most of the West Coast is gone a lot further than a lot of other jurisdictions and actually thinking about, well, this can't just mean normative access, because then we can't really have an effective criminal law. No one will know what's a crime or not. It can't just be a contract either, because just reading the statute, that shouldn't just be how these norms are set. It really should be more of a code-based circumvention in order to trigger the CFAA. We just don't have those cases yet in Massachusetts. We despite a tremendous amount of technology here, there haven't been enough CFAA cases for us to really chart that landscape yet. don't know if you can talk more about Ninth Circuit life, Californian.
Right. I think if you look at the sort of FAQ that we have for people doing reverse engineering and security research, you'll see that there's sort of bullet lists of this is high-risk activity. So this is activity where there's maybe been a court case that came out in a way that's hostile to research, or maybe there hasn't been, but the trend is in that direction. And then there will be a bullet list of these are things that you can do to reduce your risk. But in terms of saying here's the menu of things that have no legal risk, that's not something that's realistic to do. And if you tried, it would have little subheadings for, well, are you in the Ninth Circuit? Are you on the West Coast, or are you not? Just to illustrate, this is the Ninth Circuit and the Second Circuit. These just happen to be the circuits that have judged that the DMCA doesn't allow for fair uses. So you would basically have a little interactive guide, maybe, where are you? Well, what's the law right now where you are? And that's, rather than sort of creating a general purpose guide, when you have that level of immediacy or curiosity, that's when you talk to a lawyer and hopefully they have these sorts of maps and knowledge in their head and will listen to the facts of your specific situation and try to map it onto what's come before.
So we've probably got space for about 2 more questions, and please keep in mind that these lovely individuals are going to be around for the rest of the day, and so if you don't get the answer here, you can corner them over lunch.
I'm sorry to sort of double down on the thing I said before, but I just really want to hear your opinions about this, which is that, I mean, I know you guys are very legally involved, and so we're hearing about the attempts, the philosophy and the attempts to fix these laws that, and highlight the problems with them that are allowing these prosecutors to mess up people's lives. And that's clearly crucial to understand and work on. But it also has a little bit of a Band-Aid-y feeling, because it's like, to me, looking at it as a social system, like the core problem is that there are these assholes who are getting paid by the government to do this. And so I'm curious about like what ideas you all have, or someone else has, that you can refer to about ways to change this culture and this incentive system for these people. Because like if we can't change it, then like I mean, there's always going to be more holes to plug legally, right? And of course, there's also the legislative question, but like, you know, we can't just, yeah.
So the initial question, if I remember correctly, was basically a question about motivation and a sense for what motivates the prosecutions going on here. And I realize in some ways that takes you guys sort of out of your comfort zones, because you're more likely to deal with the matters of the litigation. But I actually think it would be very helpful to the extent that you're willing to go out on a limb a little bit and sort of speculate about why we find ourselves in this scenario again and again.
Do you want me to start?
Sure.
Okay. You know, I don't want to make broad generalizations about anyone's motivations, but I think I already touched a little bit about what I suspect the drivers of these overbroad statutes and prosecutions are. I would add a little bit of a nuance to what I said before, which is that you know, different actors play different roles, right? So legislators have a certain motivation to send a message to their constituents about, in the case of the statutes, we're most concerned about being tough on terrorism, right? I think prosecutors have a similar motivation, but they also like high-profile cases, and they like a large number of cases that are easy to win, right? With statutes that give them a lot of flexibility. In terms of how do we actually change the incentive system specifically for prosecutors, that's hard, but I liked what you said, Kit, about shaming. I think that's a really important point. You know, when it comes to selective prosecutions, we all know that suspect communities are most vulnerable, and the more that we have, you know, broad buy-in from the general population that doesn't consider itself to be at risk for those prosecutions, and a lot of deference to prosecutors saying that, well, if they're throwing the label terrorism out there, they must be a really bad guy, right? The more that we have that deference, the more that we're going to see a shift so that these are prosecutions of everybody and not just suspect communities. So the earlier that we can shame, I think the more protection that we have against that.
Yeah, I think it's the thing you're driving to is this idea of political accountability, right? It's this notion of like, it is often posited as the solution for bad prosecution or bad law or bad lawmakers is, well, vote them out. And it is why I think people like Lawrence Lessig have started in one policy issue and moved to the mechanisms of legislative power and focusing on why isn't this responsive to the will of the people? Because I think that in all of these cases, with some exception, we all are sympathizing with them. And the first thing we should recognize is that we are biased and we are sympathizing with the technologists because we all identify ourselves in some degree as technologists. But also that even if we do, the power of fear is just so powerful for a legislator. I mean, I think it's still true. I think we have 2 copies of child pornography laws in the criminal code today. We have 2 different chapters that are both meant to address child pornography. And the reason why we have 2 and one has almost completely superseded the other is that no one wants to pass a law removing child pornography laws from the books, right? Because it's like, what's the perception of that, right? And so, this idea that there are, it is all problems for which greater input, greater information should, in theory, help. But the most frustrating thing about all of this, and the thing that I think I'm personally most frustrated about in the realm of cybersecurity research in particular, has been there's this great push to isolate, to classify, to hide, or to punish people who are doing something as simple as trying to explain what these videos about people who are agitating against the United States are actually saying and doing, which no one seems to understand in popular media, and yet the people who are trying to actually be those bridge figures, to borrow from Ethan's words, are being punished for it.
I also think there's both an emotional and a tactical desire to control that motivates both the existence and enforcement of some of the laws. So you'll sometimes hear senators just in a frothing rage about these kids who think they can do whatever, but we're going to show them that actually we can control the hackers, we can put them in jail. And there's a former member of the military who was talking to me and said that it's really important to have broad computer laws so that you can intimidate people who are skillful hackers and make it more likely that they'll participate in government hacking rather than doing it independently, which is just an egregious use of the tremendous power that you have as a prosecutor or as a governing body.
So we're going to take a final question.
This is actually along the same lines. Thinking back to the stories this morning from Star and Jeremy, the outcomes from those actually seem, compared to what could have happened, quite reasonable for the legal outcomes. But the impact that's really damaging is the time along the way that they had to experience, that they had to go through. Like, it was great to hear that Jeremy, for example, was quite comfortable with the settlement in the end, except for a few changes to it. Along the lines of what you're talking about, do you have any ideas for how we as individuals or the organizations that you are a part of could intervene to prevent that kind of stuff from happening before?
Man, the NSA is not happy about what you just said.
The end of that question, and perhaps the end of this microphone, thinking about in cases where the legal outcome is not necessarily a hideous or tragic one, but the process is a miserable and life-changing one, which I think we can all sort of acknowledge seems to be the case for these experiences. Any way we can think about how to create an environment in which people who come under this sort of litigation are personally protected and supported in the process.
Yeah, I think the social support is a huge part of it, and so actually would be curious to hear, especially the students who are here, ideas for when a student comes under fire, how to support them. Sometimes people are advised not to talk too much about the litigation because things that they say can be used against them. But at the same time, when you're under such an intense psychological toll, isolation can be really dangerous and harmful. So in a purely non-legal sense, just the idea of socially supporting one another, both as peers and as institutions, is a really important one. In terms also of what happens when there has been a litigation under a ridiculously overbroad law or just one that's being asserted in an unjust way, even when there's a legal victory, the next steps can then be use that legal victory to extend it into other jurisdictions. So now this victory that was only in Massachusetts, we're going to get that around the country at some higher level courts. Or if the judge adopted a test that really makes sense and winds up being protective, get that written into the law or regulation so that it helps everybody.
So I want to end this session by thanking these amazing folks, thanking Kit and Andy and Shannon for giving us this contribution and all this help, and hope that you'll reach out to them for the rest of the day. I have to say, activist lawyers warm my heart.